Officer, you can bring in the jury.
Your Honor, the jury are in court.
Are the verdicts are legally sufficient? I'm going to publish myself. Mr. Quiles, you may stand with your attorney. State of Florida versus Johnathan Quiles in 19 CF 7518, Division CRI, verdict as to sentence in count 1. We, the jury, find as follows as to the defendant, Johnathan Quiles, in this case. A, aggravating factors. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to defendant Johnathan Quiles in this case. 1, Johnathan Quiles was previously convicted of a capital felony or a felony involving the use or threat of violence to another person. Answer, no. 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Answer, yes. Number 3, the first-degree murder was especially heinous, atrocious, or cruel. Answer, no. 4, first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Answer, yes. 5, IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS. Answer, yes. We, the jury, have unanimously found that the state has proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Johnathan Quiles should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Johnathan Quiles should be sentenced to life in prison without the possibility of parole, signed and dated by the foreperson. As to count 2, we, the jury, find as follows as to the defendant, Johnathan Quiles, in this case. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to the defendant, Johnathan Quiles, in this case. 1, Johnathan Quiles was previously convicted of a capital felony or felony involving the use or threat of violence to another person. Answer, no. Number 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Answer, yes. Number 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Answer, yes. The unborn child of IS was a person less than 12 years of age. Answer, yes. Number 5, the unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over the unborn child of IS. Answer, no. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Johnathan Quiles should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Johnathan Quiles should be sentenced to life in prison without the possibility of parole, signed and dated by the foreperson. Mr. Quiles, you may have a seat with your attorney. Does any side want the jury polled? Defense? Members of the jury, I have some final instructions for you. I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious or from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. On a personal note, I want to thank you for the past 2.5 weeks. We've been together for now 11 business days, and I am fully aware that when you received your summons in the mail 6 to 8 weeks ago, and then when you came here that Monday morning, this is not what you thought your month of September would go like. Far from it. Yet you showed up every single day to do good work. And I am extremely grateful for what you guys have done the past 2.5 weeks. It's not easy. It's difficult work. It's solemn. It's heavy. And I fully appreciate what you guys have been through the past couple weeks. I want you to know that there's a reason why I referred to you guys as juror numbers. It's a practice of mine, but there's been obviously a video camera here the entire time. You guys aren't captured in any of that. No one knows your identity outside myself and the attorneys. There's a reason for all that, which I'm sure you guys can understand and appreciate right now. But every day you guys showed up, and then your 4 other colleagues who didn't have the pleasure of going back in the jury room with you to deliberate. Every day you showed up, and not everywhere in the world can that occur. So I want to thank you for what you guys did the past couple weeks. It's a lot to ask of people, yet it's what our system of government demands of us. So on a personal note, I want to thank you very, very deeply for what you guys have done the past couple weeks. If you wish to follow the case at all, you can always contact my office. It's public record. And you can ask my assistant. She'll give you some information about it as well. But with that said, you guys are officially dismissed from jury service. And you guys can go about the rest of your week and the rest of your month as you deem appropriate, and with a deep gratitude for myself and from the attorneys. The jury's outside our presence. I still have counsel of the State Defense and Mr. Quiles present. What do you guys want me to do next?
Sorry, Judge. I know that Your Honor mentioned a PSI potentially, and so at this point I guess we would just request a sentencing date.
Anything from the state?
Nothing further to add. I know that if they want a PSI, obviously they have to do about 30 days out.
And Judge, I know we talked about if there was even the possibility of waiving it or not. I know we didn't get into that today in discussion, but briefly talked to Mr. Quiles about that. We don't believe it's necessary, but if it's not something that can be waived.
I think it can be waived. I think it's just because if it's a first felony conviction.
Correct, Judge.
I don't think there's any other requirement that he, in order PSI's orders, given the jury's recommendation.
Okay, Judge, then if you want us to fill out a form with him, we're happy to do that, or however you want us to do that.
I'm not sure. If he does waive, are you guys intending to move forward with something today, or do you want a separate date nonetheless? What's the state's prerogative in that regard?
They would ask for separate dates, they can give it, other individuals can give victim impact statements.
Okay, well then you guys,
We have no objection to that whatsoever. We were going to ask for a separate date anyway.
what kind of date do you guys want? It would just be for a status date, and at that point I can inquire regarding him waiving the PSI, and we can pick a new date, a new sentencing date. I would prefer to do it sometime. I would prefer to have this case, if possible, concluded within the next couple weeks, if I can do that.
Your Honor, state is fine with having a status date on Wednesday or Thursday of this week.
Sorry, Judge, I was just checking Thursday. No, I'm not available tomorrow or Wednesday.
Thursday's a bit crazy for me. I can do Thursday afternoon. At that point, I'll know my schedule for next week and let you guys know.
Thursday around like 1:30, Judge, or what time were you thinking?
Yeah, I'll make it work. That's
I mean,
fine.
I'm just suggesting.
As I sit here, I'm not sure what my schedule's like the rest of the week. I've been somewhat busy with you guys, but I'll make it work. So 1:30 is fine with me on Thursday, just for a status, and if I could do the sentencing next week, given my schedule, I'll certainly do so. I'll throw this out there. I think I had an all-day hearing Friday. I think it got postponed as possibility if you guys are available. I don't know if you guys are. I know it's short notice.
I am not, Your Honor, I'm actually at 3.
Okay, so we'll pick a date on Thursday. We'll go from there. Is there anything else we need to handle from the state's perspective?
Not from the state's perspective, Your Honor.
Defense?
No, Your Honor.
All right, I know it's been a long couple weeks. I made a few comments in the past. Appreciate you guys, appreciate the attorneys, appreciate the staff. I know it's been a difficult case the past few weeks. I recognize that, appreciate the professionalism from you guys, from the attorneys and from the staff and how they handle things the past couple weeks. Everybody involved, everything's been handled above board, and I certainly appreciate that. So I'll see you guys. What date is Thursday?
28th, Judge.
I'll see you the 28th at 1:30.
Thank you, Your Honor.
We'll be in recess.